Hello and welcome to today's edition of Trinity Talks. My name is Lucy Johnson and I am a Senior Associate based in Trinity's London office. Today I am joined by two panellists from our Washington DC office. We have partner Tom Eldert and counsel Eric Philippink. Tom and Eric will be talking today about a special relationship comparing New York law and English law in project financings. In terms of how today's session is going to run, we'll have a 30-minute presentation from Tom and Eric, followed by approximately 10 to 15 minutes of Q&A. Please do feel free to ask your questions as we go through the presentation using the Q&A feature within Microsoft Teams. And we'll do our best to try and answer as many questions as we can at the end. So without further ado, I'm going to pass you over to my colleague Tom to start today's presentation.
Great, thank you, Lucy, and welcome everybody. Next slide, please. Thanks. So today we're here to talk about the special relation between English and New York law. Our focus is generally going to be on multilateral financing transactions, but we will touch on some other areas. The topics that we'll be covering are first the background and more on the focus. Governing law considerations, when does this apply and which law should you choose if the opportunity appears? Drafting considerations when dealing with either English or New York law. And finally, closing considerations. Next slide. So our focus, as mentioned, we'll focus on multi-lender financings involving DFIs. Obviously, there are differences in other areas of law as well, insurance, EPC contracts, and other areas that may be relevant to project financing. But for purposes of this and the time available, we're limiting it to financing documents primarily. So why New York and English law? With respect to our Paris colleagues, New York and English law, as I think most people in the audience know, are the primary laws for financial transactions internationally. This presentation will focus primarily on the differences, but we should note up front that the similarities vastly outweigh the differences. Both New York and English law come from a common history. New York law obviously originated out of English law. That said, there's been some divergences over the past couple hundred years. Both New York and English law are common law, as opposed to civil law. So the main difference between common law and civil law is that common law is built upon precedent and case law, whereas civil law tends to have much more specified rules and regulations governing contracts and other matters relevant to financings. As a result, as a general matter, the general impression is that both New York and English law offer greater freedom of contract. So there's more leeway given to the parties being able to agree what they want a deal to be, as opposed to having to follow the dictates of what is statutorily allowed. In financial transactions, particularly involving commercial banks, there are standard templates. There's the LMA, the Loan Monitoring Association, Legal Marketing Association, and the LSTA, which is the Loan Syndications and Trading Association. The LMA is UK based and provides a list of template documents that can be used in financial transactions. The LSTA is US based and does the same. There's been efforts recently to try and make the two more compatible, but there are differences. And Eric will touch on a few of them, but covering all the differences could be a matter for another presentation. Again, because we're focusing on DFI financings, it should be noted that DFI or development finance institutions, and we're using that term broadly to include export credit agencies, multilateral institutions, et cetera. While to varying degrees, they may look at LMA or LSTA templates, they all have their own individual documents. I think as a general matter, the European DFIs tend to use the LMA template a lot more than the US or multilaterals might use the LSTA documentation. Next slide, please. Okay, so in terms of what should you consider if you find yourself in the situation of you have some lenders who are used to New York law, you have some lenders who are used to English law. When this comes up, and we've seen this in a number of deals, there's often a debate in terms of the common documents and which we can touch on later, also whether or not all the facility agreements need to be under one law or the other. So to make that determination, we need to examine what the differences are. So the first point is choice of law requirements. There's not a significant difference here. In New York, anybody can select New York as the governing law of a contract, whether or not you have any connection to New York, as long as the aggregate value of the contract is $250,000. There are certain exceptions, but they generally don't apply to financing transactions. That's basically for personal services and certain security UCC requirements. Under English law, there are no requirements, so anyone can pick English law to govern their contracts. The second consideration is enforcement and recognition of judgments and arbitral awards. On arbitral awards, obviously both countries are a party to the New York Convention, so there's not a significant difference in terms of enforcement of arbitral awards. When it comes to enforcement of judgments, whether it be of a New York court or an English court, the primary consideration there revolves around the host country, where the project is located and where you may need to be able to enforce a judgment. And as we'll mention a little bit later, there can be differences there. For example, some of the Commonwealth countries may have a better relationship with England. And so, as a result, it may be easier to enforce your English judgment in a country like Kenya than it would be to enforce a New York judgment. Litigation and dispute. Here there are some differences. I think as a general matter, and this obviously varies depending on the nature of the dispute and the parties, but as a general matter, litigation in New York courts tends to be more costly and take longer. Part of the reason for that is differences in discovery rules, which are more expansive in New York. So that's something to consider, particularly if you don't have arbitration in your contracts. Another big difference is the general rule for who pays attorney's costs. In New York, the general rule is that each party is responsible for their own legal costs in a dispute. There are exceptions to that for frivolous lawsuits and certain circumstances, but they tend to be rare. Conversely, under the UK law, it's the losing party pays the legal costs of both parties, although again, there are certain exceptions there where the courts may provide for more equitable relief. Another difference is in punitive and other damages. New York is more expansive in terms of the types of punitive damages they'll allow, including treble damages, which are not allowed in the UK. And finally, specific performance. There's not a huge difference here, but generally speaking, New York courts are more willing to award specific performance. UK courts can, but tend not to do so if there are adequate liquidated damages available. Next slide, please. So security documents. In addition to the common documents, another question that comes up is, should I use New York or UK law for security documents? The first question is, where is the collateral located? So if you have collateral in either the UK or in New York, then that makes that choice a lot easier. If that's less relevant, for example, if you're looking to create a debt service account or other bank account and you have the option of choosing whether to put it in London or whether to put it in New York, then that's less of an issue. The second point to note is, while we mentioned earlier that both legal systems are common law and rely on court cases and precedent, the one exception in the U.S. is the Uniform Commercial Code, the UCC, which basically puts fairly pro-contracting provisions, but it has a statutory prescription for how you perfect security. The advantage of that is that it does give a little more certainty in terms of the process that's to be followed for perfecting security, and also on outcomes. All that said, the final most important thing is really the commercial consideration. So, for example, with respect to bank accounts, do you have a relationship with an English bank or a New York bank? Is one cheaper than the other? That's probably more important than the actual governing law of the security documents, as well as making sure it's consistent with the other financing documents. Another small difference is on statutes of limitation. So in New York, it's 6 years. Under English law, it's generally 6 years for regular contracts, but it's 12 years for deeds. So that's something you may want to consider in terms of drafting documents, which Eric will be getting into in a moment. Next slide, please. So as you can see, the actual differences aren't significant. And so I think of much more importance are practical considerations. So one point is Commonwealth countries. Commonwealth countries tend to have a closer relationship to English law. And so much as I'd prefer people use New York law and hire us, the reality is in certain jurisdictions, the judicial system and the local council will be much more familiar with English law, and so that may give you an advantage over New York law. Conversely, in areas like Latin America, the reverse may be true. They're much more familiar with New York law. International politics. One of the benefits of DFI involvement in transactions is benefiting from the potential for political leverage against the host government. And we've seen this happen many times where there's pressure put on a project or a borrower by a host government, and the DFI steps in and helps resolve the situation, whether it be a fight over tariffs or tax investigations that may not really be tax investigations, that type of thing. So here you do want to consider international politics. Some countries may have a stronger preference or a closer relationship with either the US or England, and so that's something to keep in mind. Familiarity, I touched on this a minute ago, but basically what are the parties to the transactions most familiar with? If the majority of lenders and their boards of directors, the sponsors, local counsel, if they're more familiar with New York law than English law, then it will make the transaction easier if you go with the law that they're most familiar with. Conversely, if folks are much more familiar with English law, then that makes that a better decision. And that ties into the final point, which is additional costs. Obviously, if parties are less familiar with the law, then that's going to lead to additional costs as they get comfortable with it. And with that, I'll pass on to Eric.
Great. Thank you very much, Tom. In this next part of the discussion, we thought that we would highlight a few areas related to the drafting of finance agreements, where we see some specific differences in the New York and the English law approaches. And our recent experience has shown that these cultural differences, if we could call it that, can arise in a few different contexts. As Tom said, that we are talking here today about multi-lender contexts. So let's say, for example, we take the U.S. Development Finance Corporation, formerly known as OPIC, and now called DFC. They normally use New York law agreements. And so let's say that they will be lending together with one or more European DFIs. and the European DFIs are much more used to English law agreements. Now, after going through the decision tree that Tom discussed, one governing law is chosen, but you must still accommodate both approaches in a single agreement, in a single common terms agreement. Or let's take another scenario, such as when you may have a European DFI who is making a loan into Latin America, and although the loan agreement may still be under English law, you may be faced with borrower's counsel who may be a New York lawyer and used to negotiating commercial contracts under New York law. And so they will view English law provisions through a New York law lens, and they will see things and give you arguments as to what is current New York market practice and not necessarily what you are used to in your English law context. So maybe just here also an initial word about our references to the LMA and the LSTA, which Tom mentioned also in his introduction. As Tom said, the LMA offers English law templates and guidance for credit agreements, intercreditor agreements, and the like. And the LSTA does the same for New York law. Now, both are aimed at the commercial banking market, but the LMA models do provide basic templates used by international financial institutions and European DFIs in their credit agreements. And while the DFC template does not rely on the LSTA model as such, certain provisions are certainly inspired by it. And when questions arise over wording or current market practice, we would see that lawyers would turn to either the LMA or the LSTA and use them as sources of guidance, even in the development finance context. So let's talk first about policy requirements. This is the first example where we see drafting differences. And when I refer to policy requirements, I'm going to focus here on policy requirements for anti-corruption, anti-money laundering, and sanctions. Sanctions, otherwise known as combating the financing of terrorism, which we often see shortened to the expression AML-CFT. The differences in these policy requirements can be seen not just in what is provided for in the templates for the multilateral lenders and European DFIs under English law, or under the DFC template for New York law, but also in what the LMA and the LSTA provide in their respective commercial markets. Now, we could do an entire presentation on anti-corruption, anti-money laundering, and what the provisions are. But for the sake of illustration, and please go to the next slide. For the sake of illustration, I have pulled together this table to show you the differences that you will find in how defined terms are used in each of the individual templates. This table is broken down by row, anti-corruption, anti-money laundering and sanctions, and for the respective LMA, European DFI, or LSTA and DFC templates. All the words used in these boxes are the defined terms that I've taken from each of the various templates. I admit that throwing this chart, this table up on the screen is a little bit overwhelming, and that is the point. I've done this illustration really to make 2 points to you. First, in a scenario involving multiple DFIs, considerable legal drafting effort will need to go into merging the policy requirements in the finance documents, because each set of policy requirements, either from the English law perspective or the New York law perspective, they will have their own set of defined terms, and each of those defined terms are meant to work together. And if we go to the next slide, please. The second point I wanted to make in this box here that's highlighted in yellow, it contains an interlocking set of policy requirements under the umbrella term of sanctionable practices. You can see here that the related terms that are listed: coercive practice, corrupt practice, fraudulent practice, which some of you may be very familiar with. These terms do not have an equivalent in your typical New York law finance agreement. Such an agreement would more typically refer to specific anti-corruption laws, such as the Federal Corrupt Practices Act. So Here, we would say that the sanctionable practices are more behavior oriented, and you could consider them to be quite broad because they're not necessarily speaking only about breaches of law or criminal behavior, but also just simple behavior and practices. And therefore, when you are faced with, say, borrower's counsel, who is a New York commercial banking lawyer, they might be unfamiliar with these sets of policy requirements and will want to push back on them. And if this is the case, a conversation will need to take place to explain how policy requirements are used, their importance for the DFIs, how they are required and cannot be changed, and how they are meant to work in a development finance context. This is where you may come across some cultural differences if your New York-based lawyer is not necessarily familiar with them. Let's go on to the next slide, please. Having set aside the policy requirements, I want to refer to another area of difference in terms of representations and warranties. This area of difference between an English law approach and New York law approach is that in each respective body of law, the treatment of representations and warranties will be different. And the templates also reflect this. For the LSTA and for what you would find in the DFC template, your reps and warranties will be made at the time of signing on the execution date. And then when you have a drawdown, there will be a closing certificate attached to your disbursement request, and this certificate will bring down the representations on the disbursement date. By contrast, the English law or the LMA approach will structure your representations and warranties as being given not only on the execution date and then repeated at each drawdown, but they will be repeated yet again on each interest payment date throughout the life of the loan. In New York law finance agreements, we generally do not have repeating representations. Now, some European DFIs will take, let's call it a maximalist approach as their starting position, and they will require that all of the reps and warranties repeat on all of those times that I have described. And effectively, these make those reps ongoing obligations throughout the life of the loan. Now, this may be perceived negatively particularly by the New York finance lawyers who are unused to this approach and do not want to see these ongoing obligations from the reps and warranties. They will push back and they will say that such ongoing obligations should be confined to your covenant section. They do not want to be tripped up by, say, a breach of one of the reps and then also a breach of the covenant on the same issue that would lead to an event of default. So your fallback position from this maximalist approach, and indeed it's what the LMA template already provides for, is that only certain of the reps will actually be repeated. So this means that lenders together with their counsel will identify which representations and warranties will be repeated, and then which issues can be covered by the covenants or undertakings. I move on to our next point, which is assignment versus novation. With respect to treatment of new lenders coming into a transaction, I will point out that there is a difference under New York law and English law on how this is done. Under English law, a lender can assign its rights, but a transfer of its obligations must be done through a novation. So you will find that English law credit agreements will attach forms of novation agreements for new lenders, whereas under New York law credit agreements will merely attach an assignment agreement to effect the same results. And in addition, you will find in the LMA template and the LSTA template differences that will be in the body of those agreements. So your changes to lender section, for example, in the LMA template will differ from how the LSTA treats their provisions on successors and assigns. A point to make about agreements to agree. In certain cases, you may be familiar with how deadline pressures can build up, or for other reasons, the parties may not come to agreement on all terms in a transaction, and they may effectively agree at a later date to settle those terms. Now, New York law will differ from other states in the US, and New York law will treat such agreements to agree as obligations to negotiate in good faith, although there is no obligation to reach a final agreement. Under English law, however, such agreements to agree have traditionally been held to be void for uncertainty, and therefore we point out that these could potentially be unenforceable, and so you will want to be careful about including them in your agreements. I mentioned negotiations in good faith. I will mention here that the concept of good faith is yet another difference between New York and English law. Under New York law, every contract contains an implied duty of good faith and fair dealing, and that requires that neither party will do anything to destroy or injure the rights of the other party. By contrast, English law does not recognize such an implied duty, and English law contracts must therefore expressly impose a duty to perform an obligation in good faith if this is what is intended. I will make just a brief mention here about other terms that you will see thrown into agreements, such as best efforts or reasonable endeavors, commercially reasonable. These are terms that lawyers often argue about. These qualifiers will be very fact-based and very context-specific. So it's hard for us to make a generalized statement as to the treatment under New York or English law. So I just urge some caution and a need to discuss them with your counsel. Let's go on to the next slide. Having pointed out a few of the drafting considerations when you are looking at a New York law document compared to an English law document, we also should point out that when you are closing your transaction, there are certain considerations to be made when you are completing your conditions precedent, because there are differences that you will find in New York practice from English law practice. The first I would like to address is the perfection of your security. And you will generally not find that even if your finance documents are under English law, and we're speaking about a development finance context here, it will be unlikely that you will need to perfect your security in England, because for the most part, assets will not be held there. But if for some reason you did need to do that, you would file your all assets debenture at the company's house in England. But for the most part, when we're talking about development finance, your collateral will be located in a local jurisdiction. And so you would need to work through local counsel who will advise you on your requirements for perfecting security there. And these will tell you which registrations must be done. But as Tom mentioned earlier, we would have, along with a New York law credit agreement, a New York law security agreement as well. And under New York law, you would perfect your security interest in several ways, and it will depend on your type of collateral. You can perfect it through possession, for example, in the case of certificated securities or stock certificates, control in the case of deposit accounts, and for this you would need an account control agreement. But for most types of collateral, you would perfect your security through filing a UCC financing statement. Now, we could spend an entire session, an entire hour, just talking about perfection of security under New York law. We're not going to do that. So just out of interest for the audience, I'm going to put up here on the next slide an example of what a UCC financing statement looks like. Many of you in the audience may have heard expressions such as that you would need to file a UCC but not known what it means. This is what it looks like. It is a single page form. And if we zoom in on the next slide, This is the important part of the form. And the point I want to make here simply is this. This form is a single page and it looks deceptively simple. You simply fill out the name of the borrower, you fill out the name of the secured party who would be your security agent, and you describe your collateral. It seems simple, but I cannot stress to you how many mistakes are made in completing this form. There have been quite a few famous court cases where lenders thought that they were secured for hundreds of millions, even in one famous case over $1 billion, but mistakes were made with this form, and these lenders suddenly found themselves that they were no more than unsecured creditors, and in a bankruptcy scenario, they were unable to recover or recovered very little. So lenders and their lawyers need to take particular care with this form to ensure that it is filed properly. This means in the case of a US borrower, you file it in your state where the entity was formed, and in the case of a non-US borrower, it should be filed in Washington, DC. Let's go back on to the next slide, please. Some comments about legal opinions, because this we often see as a difference in approach. So the preparation of legal opinions will differ in New York from English law practice, and sometimes we find confusion over who will do what. In New York law, typically the borrower's counsel will prepare your legal opinions, and this will cover a full range of issues, including capacity, due authorization, and execution, as well as the enforceability of the agreements. Under English law, this will be different. Lender's counsel, not the borrower's counsel, would typically provide your enforceability opinion, and this is because lender's counsel will have taken the lead in drafting the agreements. By comparison, then, borrower's counsel will have the responsibility for your opinion as to the capacity and due authorization, because borrower's counsel will have had the responsibility for forming or incorporating the entity. And some words about your signing procedures and execution requirements. Now, we touched upon signing requirements during our earlier episode of Trinity Talks when discussing closings during COVID. And I just wanted to raise it again here because, again, there is a very clear difference in the practice of executing documents under English law. Those of you who may be familiar with signing documents that are New York law documents, you may have experienced a signing process whereby signature pages are broken out, circulated in advance, and the parties are simply told, sign these, and the lender's counsel will hold them in escrow, sometimes even weeks in advance. This will not happen under English law. The signature pages will be held until the entire agreement is concluded. The flexible approach that you saw under New York law agreements will not apply here. You will find that a very strict protocol needs to be followed under English law. You will receive from the lender's counsel signing instructions with a very detailed set of tasks that will need to be followed. Parties will need to send back not just their signature page, but also a copy of the full agreement, and then authorize lender's counsel to attach and compile the final version. And I point this out because it's really a difference in practice that may be quite surprising, because failure by the parties to follow the signing instructions may actually lead to the closing being dragged out. And when you're under time pressure, this becomes a problem, because the agreements cannot be dated until the receipt of the final signature page from the last party. And so compliance with these instructions is necessary. And just one brief word, Tom mentioned deeds. Some English law documents take the form of deeds, and these have additional requirements for execution. Namely, you need to have them signed by witnesses. And so particularly in the context of our recent COVID shutdowns and lockdowns, organizing witnesses can pose its own logistical issues. And so you may want to think about this in advance. Let's move on to the next slide. So in conclusion, I just want to wrap up and leave you with a few takeaways and summarize what we have discussed here today. So first, your decision to choose either New York law or English law for your finance documents, these will tend to be very deal specific. It will depend on the parties, depend on where they're located, where your project is located, where the collateral is located. The choice is going to be the result of a cost-benefit analysis overlaid by some practical considerations. As Tom mentioned in the beginning, for example, some of these considerations may be enforcement and recognition of judgments. Where could a judgment be more easily recognized, for example, in a former Commonwealth country, where decisions rendered by an English court are automatically recognized. But to this, we should also add the considerations of drafting, because bringing together your English law approach, your experience with New York law, making two agreements work together requires considerable drafting to merge these different sets of provisions. We pointed out some definitional terms that need to be merged, and quite a lot of care needs to be taken to put these into a single document. A mistake that many people make is thinking that you can just use the same agreement and change the governing law provision. Take a New York law agreement and say it's now governed by English law. It's not that simple, and we have highlighted some of those differences in both the approach and the requirements for your closings. And so finally, we would say that you really do need to consult with your counsel to provide you and give you advice on which is the better choice for you, New York or English law, and from that, how to make your drafting and closing procedures comply with those two different bodies of law. And now with that, I will hand it back to Lucy to see if we've had any questions come in the meantime.
Thank you very much, Tom and Eric. I found that very interesting, particularly from the perspective of an English law qualified lawyer who hasn't really been involved in any New York law deals. We've had a number of questions come through during today's presentation. I think we've got a few minutes to deal with those now. I will start off by passing across to Tom. We've had a question which is, why are New York law security agreements so broad, and are they really necessary when there may not be collateral in New York?
Thank you, Lucy. Yeah, that's a good question and one that we get asked from time to time, particularly representing U.S. lenders. The reality for why they're so broad is because they can be under New York law. Do they need to be in a transaction where there aren't any assets in New York? Technically, no. However, if you do have some assets in New York, for example, oftentimes they're paired with a collateral accounts agreement held by a bank in New York. It's actually better just to keep the broad security agreement for the simple reason that it's more cost effective. The security agreement tends to be one of the least negotiated documents in the transactions that we work on. And the reality is there are certain benefits to the lenders. There's intangibles, some other collateral that you could potentially get security over. But for the most part, for project finance transactions, the assets are going to be located in another country. And so you'd really be looking for your local security to enforce that. So I think the takeaway is if you have any New York collateral at all, like again, an accounts agreement, you're better off just keeping the big, broad New York law security document and not wasting time and money trying to negotiate it.
Great, thanks very much, Tom. Eric, I've got a question for you now. If a borrower is refinancing, with a new group of European lenders who have perhaps different policy requirements from existing US lenders, how would you go about dealing with that?
Thanks, Lucy. This will require some thought on how you would want to structure your agreement, because you have an existing agreement that's in place. And if I understood from the question, you would have, let's say, an existing New York law agreement, and then you have a new group of lenders that's coming in that may expect to have an English law agreement or are used to the English law approach. Now, the question focuses on something that I mentioned in touching on the policy requirements. Those new lenders will have their own set of policy requirements, and the existing agreement may or may not have the same policy requirements. And so we would try to merge the two sets of policy requirements in this way. One way would be to do it by adding schedules that would be specific to the new lenders, for example. Schedules that would have their own sets of definitions so that they don't, in a way, disrupt the existing agreement that is already in place with the borrower. Another way could be to keep those policy requirements within the facility agreement for the new lenders that would be connected to the common terms agreement. You could do it that way. And then I would say that probably the next thing that you need to consider is how this will be worked out in your intercreditor agreement, because the intercreditor agreement will bring together both groups of lenders. And so when you have policy requirements that are specific to one or more lenders, and you consider the voting requirements in how decisions are made, or in the case of policy requirements that might trigger an automatic event of default going to repayment of the loan, you would want to work that out also in your intercreditor agreement. So that is another consideration that you need to bring into this. It's not just your common terms agreement or facility agreement, but also your intercreditor agreement that needs to deal with these different sets of policy requirements.
Thanks very much, Eric. I'm very conscious that we're coming up to the end of our allocated time for today. So I think just before we wrap up, we just wanted to give you a quick reminder that all of our previous talks are now available to view on YouTube. So we've got the link here in the slide. Also, we wanted to remind you that we are now having a couple of weeks break for the summer, and we will be reconvening in September. So the next session will be on the 2nd of September with rate fixing and an update on where we are with LIBOR replacement. So thank you very much for joining today's session. Hope you have a great summer break and look forward to seeing you in September. Thanks very much.